This Honorable Court of Appeals of Tennessee is now in session.
Good afternoon and welcome to the Court of Appeals. We appreciate you agreeing to participate, you and your clients agreeing to participate via Zoom, this oral argument. We think it's the best method to utilize at this point in time. However, both of you are experienced practitioners. You've been to the Court of Appeals many times. We will be utilizing the same rules, procedure, and protocol that we always use in the Court of Appeals. So consider yourself standing in the courtroom today, even though you're not. What that means practically is that each side gets 15 minutes to make its oral argument. If you're the appellant, you've reserved rebuttal time with Mr. Hibner beforehand. You'll receive that rebuttal time. Before we get started today, I want to be sure and introduce our panel. We have Judge Kenny Armstrong from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. And we appreciate you being here today. Mr. Hibner, anything we can take up before we call the case?
I know.
They call the case.
James A. Welch et al. Versus Oaktree Health and Rehabilitation Center, LLC, doing business as Christian Care Centers of Memphis et al.
Thank you. We will hear from the appellant.
Thank you, Judge Stafford. May it please the court. My name is Christy Kreider, and I represent Christian Care Center. Christian Care Center is a healthcare provider that relied in good faith on a healthcare power of attorney document that is valid on its face. In that document, David Welch chose his brother, James Welch, to help him with his healthcare decisions. As part of that admission and pursuant to his healthcare power of attorney document, James entered into an arbitration agreement on behalf of David. The trial court failed to follow controlling Tennessee law and looked beyond the four corners of the healthcare power of attorney document to find that the POA was invalid. After doing so, it refused to enforce the arbitration agreement. This court should reverse the trial court for two reasons. First, the court should uphold the statutory right of a healthcare provider as interpreted by our Tennessee Supreme Court and the Western Section Court of Appeals to rely in good faith upon a power of attorney document. This court's analysis should end there. If this court reaches the second question, it should decline to take away David's right to choose his brother to make his healthcare decisions for him. The facts. David lived in an adult group home, the Door Home, for 28 years due to his diagnosis of Down syndrome. He held a job, both making boxes and in the cafeteria. He rose to a leadership position. While he was there in 2009, 10, and 11, when he had been there for some 20 years, they permitted him to sign his own healthcare consents in order to obtain vaccinations. In January of 2012, we're 4 years in time at this point prior to the execution of the arbitration agreement. January of 2012, David needed to have cataract surgery. His brother James wanted to help him arrange to have that cataract surgery, so he met with a surgeon. And the surgeon said, "You're going to need to procure a healthcare power of attorney from your brother in order for you to help him make these arrangements." And so James did just that. And that power of attorney document in the court's record is valid on its face, and it gives his brother James the right to make healthcare decisions for David. That document was not only witnessed by his brother, who testified that he watched his brother sign it, but it was also witnessed by two witnesses who we have their testimony under penalty of perjury contemporaneous. And if you look at the last page of that durable power of attorney document, David, who we know was their neighbor, and their former sister-in-law, who the record shows had known David for many, many years, both swore, number one, that David was personally known to them, number two, that he signed it in their presence, and number three, that he appeared to be of sound mind and under no duress. The appellee raises no issues with the validity of the power of attorney document on its face. David neatly signed his name, including his middle initial, and he chose his brother, a very logical decision, his closest relative in the world, to make his healthcare decisions for him. The two of them enjoyed the benefits of this healthcare power of attorney document for 4 years prior to the signing of the arbitration agreement in question. And during those 4 years, the testimony in the record is that every single healthcare provider that James presented the power of attorney document to in order to help his brother with healthcare decisions accepted it. Every single one of them. That included the surgeon who performed his cataract surgery. That included the surgeon who performed his hearing implant surgery. And that included 2 additional hospitalizations. Fast forward 4 years to 2016, when David is being admitted to Christian Care Center. At that time, James showed up with the same healthcare power of attorney document that they had been operating under for 4 years. And he presented that document to the Christian Care Center admissions coordinator as his authority for admission to Christian care. The testimony in the record is that every time he presented this power of attorney document to a healthcare provider, he told them the same thing. I'm not sure if it's valid or not. I printed it off the internet, and his quote was, "It is what it is." All of those healthcare providers relied upon that power of attorney document in good faith, as did Christian Care Center. Also on the day of admission, using that power of attorney document, James executed a do not resuscitate order in favor of his brother. That order was required to be reviewed by David's treating physician. He had to note who he was relying on to make that healthcare decision, that life and death healthcare decision. And the physician noted that his brother James was making that decision for him. He noted that it was pursuant to the power of attorney document, and then he signed off on it as well. Within 2 days of Christian Care also relying on that same document for James's execution of the admission documents. The procedural history is that a motion to compel arbitration was filed, lots of briefing happened, depositions happened, there was a hearing. Critically, there was no evidentiary hearing. The court ordered that the motion to compel arbitration was denied, finding that the arbitration agreement was invalid solely based on the fact that the underlying POA, when executed in 2012, that David did not have the requisite capacity to execute it. This appeal was timely taken, and the reason that I mentioned that there was no evidentiary hearing is that that is critical for this court's standard of review. Not only are questions of law de novo before this court with no presumption of correctness, but the Supreme Court in the Kelly decision also held that when there is a factual finding that is purely based on evidentiary evidence, non-evidentiary evidence, and simply documentary evidence, that there also shall be no presumption of correctness. So that takes us to the Tennessee statute in question, along with the Tennessee Supreme Court and Western Court of Appeals decisions that are directly on point. Tennessee Code Annotated 34-6-208 provides that a healthcare provider has the right to rely in good faith on a healthcare power of attorney document that is presented to them. In Owens, our Tennessee Supreme Court hit head on the issue that is before this court today, and that is, are they entitled to rely on that healthcare power of attorney document when making a decision to allow that person to sign an arbitration agreement as part of being admitted for healthcare services. In that opinion, our Tennessee Supreme Court noted it was addressing 6 numbered issues. The only one we need to worry about today is issue number 2. And that was articulated by the court as whether King's durable power of attorney for healthcare authorized her attorneys, in fact, to bind her to arbitration. In answering that question, they made 2 key findings that dictate this court's decision today. The first is that the decision to sign an arbitration agreement as part of admission to a healthcare facility is a healthcare decision and is within the scope of the powers of a durable power of attorney for healthcare. That is not disputed by the appellee. Question number 2 brings us to the question before the court today, and that is whether the court can dig down into outside the 4 corners of the document and look back in time, in this case 4 years back in time from the date of the signing of the arbitration agreement and 9 years removed in time from where we are now, and study the circumstances surrounding the execution of that power of attorney document. And the Owens court held this is an instruction back to the trial court. Discovery should not be permitted concerning the validity of the power of attorney or the circumstances surrounding its execution. Tennessee Code Annotated 346208, providing immunity to healthcare providers who rely on decisions made by an attorney in fact who the healthcare provider believes in good faith was authorized to make healthcare decisions. This Western section of the Court of Appeals put an exclamation point on the Tennessee Supreme Court's decision when it decided the Duke case. And in that case, it was a general power of attorney that was in question rather than a healthcare power of attorney. And the plaintiff, and I believe Mrs. Sarah represented the plaintiff in that case, wanted to do discovery on the circumstances surrounding the execution of the original power of attorney. And the court found, and the defendant said, no, you've got to look to the Owens case. The Owens case says we cannot do that. And here's what the Western section said in Duke. TCA 346208 governs durable powers of attorney for healthcare, and it is inapplicable to the general durable power of attorney executed by Mr. Duke. The Owens decision does not prevent the trial court from considering the validity of the general power of attorney in this case. The defendant's argument regarding the wisdom of applying the same rule, referring to the rule in Owens, to general powers of attorney is a matter for the legislature and not for the court. And respectfully, Your Honors, this also is an issue that is before today for the legislature. They have addressed it, as has our Tennessee Supreme Court. Thank you.
We will hear from the appellee.
Good afternoon, Your Honors. Carrie Sarah on behalf of the plaintiff appellee in this matter. May it please the court, the trial court's decision to deny the nursing home's motion to compel arbitration was correct and should be upheld for 3 reasons. First, the court correctly looked behind the healthcare power of attorney to determine David Welch's capacity to execute that document. This was a Mississippi power of attorney, not a Tennessee power of attorney. Nowhere within the power of attorney did it reference the Tennessee Healthcare Power of Attorney Act, which is markedly different than the healthcare power of attorney at issue in Owens. And it was the language from the Tennessee Healthcare Power of Attorney Act and the incorporation of its terms into the power of attorney that led to Justice Holder's decision in Owens and the applicability in footnote 4 of that section 208 regarding a healthcare provider's immunity. So that's why Judge Stokes was right when he held at the January 2020 hearing that he was going to look beyond the four corners of this healthcare power of attorney. We argued at that time this was an out-of-state power of attorney, and so he determined he could look behind the power of attorney to figure out the capacity to execute of the principal. So of note, the defendants did not appeal that order. So the trial court then subsequently at our May 2020 hearing correctly upheld our position that Mr. Welch was incapacitated by finding that he lacked the requisite capacity, having suffered from a lifelong intellectual disability that had led him to never be able to care for himself in his entire life. The facts of his circumstance are very akin to the Knight versus Lancaster matter, which is another Western Section case that involved a determination that a gentleman was incapacitated where he had a lifelong low intelligence and was not beyond intellectually an 8 or a 9-year-old. Here we have clear, unrebutted testimony that Mr. Welch's mentation was that of a second grader or less for the entirety of his life. So this wasn't a circumstance where he had at one point had capacity, lost it, regained it, lost it again. It wasn't that situation. He was perpetually incapacitated. And then the trial court also got this right in denying the motion to compel arbitration because the plain language of the statute from the Tennessee Healthcare Power of Attorney Act in Section 208 regarding the immunity of a healthcare provider, it simply doesn't apply to this circumstance. That statute is very clear that it only applies, and I'll read to you, it says a healthcare provider is not subject to criminal prosecution, civil liability, or professional disciplinary action, and pertinent parts, if the healthcare provider relies on a healthcare decision in good faith. So here we have a circumstance where the Tennessee Healthcare Power of Attorney Act does not even apply to this power of attorney, it being an out-of-state power of attorney executed in Florida for a Mississippi resident, and it references Mississippi law, as Ms. Kreider had pointed out in the witness sections. So the plain language of that immunity statute would not apply to this circumstance to allow this healthcare provider to rely on the power of attorney. It's just, there's no need for immunity for this act. You know, the act we're speaking of here is whether a resident's brother can sign an arbitration contract for this nursing home resident. That's not the type of act that would expose the nursing home to some type of civil liability, criminal prosecution, or professional disciplinary action. So Section 208 simply doesn't apply. And then again, even if it did, even if we just accept and impute the provisions of the Tennessee Durable Power of Attorney Act into this power of attorney that never references it and wasn't executed in Tennessee or about a Tennessee resident, even if we do use that provision here, there is no circumstance under which the nursing home could have had a good faith basis to rely on the healthcare power of attorney. And I'm not sure how much experience this panel has with nursing homes, but Ms. Kreider and I know from years of representing them or having cases against them, the nursing home is required by federal and state regulation to research the medical conditions of any prospective residents before admitting them. There's a whole clinical process they have to go through. They have to get medical records. They have to have the head of the nursing department assess the patient, determine they can admit them before allowing the resident to come live at the building. So there is no doubt that the nursing home would have known of Mr. Welch's lifelong low intelligence, Down syndrome, the fact that he lived at a home for the intellectually disabled for 28 years, the fact that his brother, when he was asked if he had a power of attorney, presented this healthcare power of attorney and expressed his own doubt as to its validity. And then if you look at the power of attorney, as these healthcare providers are trained to do, because I will tell you, Ms. Kreider and her group they've done a great job of representing this nursing home chain. They train their representatives in the presentation of the arbitration contracts, train them about powers of attorney, what to look for, when is it valid, what's a healthcare surrogate, when is it valid, and they teach them these things. So if this nursing home is going to engage in the presentation of contracts and do these lawyerly things, they should be held to the same standard and not given a pass and not be allowed to.
Ms. Sarah, let's confine ourselves to the record.
Oh, yes, sir. Yes, sir. Fair. So the point is, though, when they are given the powers of attorney, in this circumstance where they're given the power of attorney, the healthcare power of attorney, it's 4 pages long. It is single spaced. It's at best 10-point font. It's very specific in its direction about what powers it will lay out. And it advises that the principle that you can limit these powers if you just say so within the document. Well, this gentleman, Mr. Welch, at no time in his life could he read. He had problems seeing at the time that this document was supposedly executed in 2012. And the whole point of his brother bringing him to Florida was to have some cataract surgery done. The unrefuted testimony is from his brother regarding the presentation of that document.
Well, let me stop you there.
Yes,
I'm told Ms. Kreider says it was no evidentiary hearing, and that apparently the trial court based its ruling on documentary evidence. Is that accurate?
That is true. There were depositions that were taken and submitted to the court. So those are the documents.
So the depositions were considered as testimony.
Yes, sir. They were.
Thank you.
Yes, sir. We had the deposition testimony of Mr. Welch and the deposition testimony of Dr. Lassane and the deposition testimony of Ms. Reeves, who was the nursing home's representative, who presented the contract. All were filed before the court and considered by the court in their totality. So I believe that all of that evidence was considered. Ms. Reeves, the nursing home's representative, she had no memory of the interchange or the admission process or of any part. She did testify as to what I was getting to earlier about the review process and how they would have to get records and be aware of Mr. Welch's medical condition and prior to their admitting him to the facility. And I would point out on this power of attorney, a couple of more aspects that I think would lead any reasonable provider to call it into question. In addition to Mr. Welch's lack of mentation, well explored in the medical record, his history, his brother's statements. On the power of attorney, the two folks that witnessed the document, one of them is the ex-wife of the agent. She shares the same last name as the agent and the principal, which for any reasonable provider, I would think would make them call it into question after certainly the brother says, I don't know if he had the mentation to execute this document. Also of note, there is no attorney involved in the drafting or execution of the power of attorney, as is plain from the face of the document. There is no notary seal on it. So I think this circumstance is much more akin to what we see in the Knight versus Lancaster case I brought up earlier from this Western section, and also the Francis versus Barnes case, which Judge Stafford, you were on that panel. That was a case where a grandmother who was a landowner signed over a deed of land to her grandsons. The proof in that case, and that was a case where the trial court heard 24 fact witnesses who ranged full spectrum on the landowner's mental capacity. But ultimately, the trial court determined the proof had shown she had suffered from Alzheimer's or dementia for the last 2 years. She had been repetitive and forgetful. And what was important that the court considered was that there was no evidence presented that her condition had changed or improved around the time that the deed was signed. So she, as here, had a baseline condition, a complete baseline condition of confusion, and there was no presentation of proof that that had varied or improved in any regard. And that's important here because we're dealing with Mr. Welch, who had a baseline condition of intellectual disability to the point that he was never in his life able to care for himself, just like the individuals whose capacity was at issue in the Knight versus Lancaster case, where in that case, that gentleman worked on a farm. He could hold some minor farm jobs. He drove a car, but he never could handle his own money. He was like an 8 or 9-year-old. And the court said, yes, for the transaction at issue, he would not have had the capacity. So the Western section had decided in that case that his bank transfers as a result were null and void. And the same should be said here. Capacity, as we see in the Duke case, as we see in the Kazoka case, I don't know if I'm saying it right, CZOKA, it is a fact-specific inquiry. And I know the appellant has taken the position that we need to be able to show as of when the power of attorney was signed, January of 2012, what his mental capacity was at or about that time. But I would say Kazoka doesn't say that. If you look at footnote 5 in Kazoka, the court says, we're just letting you know we're looking specifically at the time frame and issue in this case because Ms. Kazoka had varying levels of capacity. She had been an assistant professor at Boston University. So she had good days and she had bad days, and they wanted to look at how she acted in response to the transaction. But the Court of Appeals went out of its way to add that footnote to say, in this circumstance, that makes sense for us to do. But this is such a fact-sensitive inquiry. You have to look at the facts of each case as to what evidence makes sense and what you look at. And so for Mr. Welch's case, we're again back to the situation in Knight, where we have a lifelong disability. It never waxed, waned. It stayed very consistent, that he could not care for himself or live on his own at any time in his life. And of all of the records that were put in into the record in this case, the medical records, those behavior logs from the Bador Center over 7 years, they showed no significant improvement or change to his mentation or condition. He lived the same as he had his whole life, unable to read, without the benefit of education, in a supervised environment, in need of cataract surgery and hearing aids. So this gentleman was not competent to execute his healthcare power of attorney. If the court is not convinced, we would ask that you remand for a decision on the unconscionability argument that the trial court did not address when it decided this matter. But I think the court has enough here to protect those intellectually disabled individuals from their rights being able to be taken away from them. Thank you, Your Honors.
Thank you. We will hear the rebuttal of the appellant.
Thank you, Judge Stafford. To address 3 points made by Mrs. Sarah. First, that 34-6-208 of the Tennessee Code does not apply to a healthcare provider's reliance on a healthcare power of attorney document for purposes of execution of an arbitration agreement. Our Tennessee Supreme Court in the Western Section Court of Appeals addressed that head on in the Owens and Duke decisions, and both found that it does apply. Second, Your Honor, that the protections in that statute provided to Tennessee healthcare providers do not apply to powers of attorney documents executed in other states. There is nothing in 34-6-208 that carves out a Tennessee healthcare provider's right to rely on a healthcare power of attorney document only if it's executed in the state of Tennessee. Third, with regard to Mrs. Sarah's argument that Christian Care Center was not in good faith in relying on this healthcare power of attorney document. Her first argument, Your Honor, is that they should have known that 4 years prior, there may have been some questions with regard to his capacity. There is absolutely nothing in the record to reflect that Christian Care Center should have known on the day that Mr. Welch was admitted in 2016, any issues they may have existed with his capacity back in 2012, except that we all know that we knew that he was diagnosed with Down syndrome. The proof in the record before this court is that there are individuals with Down syndrome that function almost fully independently, and there are zero questions about their capacity. And finally, Your Honor, in addressing that good faith, let's look at what the Tennessee Supreme Court has said about the test we should apply when looking at someone's capacity. Our courts jealously guard an individual's right to retain the ability to make healthcare decisions for themselves. And this was a very simple decision that David was called upon to make. And that is, would you like your brother, the person with whom you are closest in this world, to help you with your healthcare decisions? And his answer was yes. Our courts have said this court should start with the presumption that David keeps the right to make that decision for himself. And it is only if clear and convincing evidence is presented by the opposition that that right can be taken from him. This court should not do that. Thank you.
Thank you. We will take this matter under advisement and attempt to provide you with an opinion at the earliest time possible. Appreciate you being here and appreciate your arguments. Ms. Tibner, if you will recess court, please.
This honorable court is now adjourned.
Thank you.
Thank you.
Thank you, Your Honor.